The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
The Committee on Judiciary, to which was referred CACR 25, an act relating to the Supreme and Superior Courts, providing that the Supreme and Superior Courts shall not be constitutionally established courts. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Joseph M. Hagan for the committee. The question before the House is the committee report of inexpedient to legislate on CACR 25. The Chair recognizes the Honourable Member for Newmarket, Representative Davenport, to speak to the question.
Thank you, Mr. Speaker. Thank you, fellow representatives. Before you is CACR 25, an amendment to remove Article 72A of Part 2. Article 72A was created by amendment in 1966 and established the Constitutional Court. The argument out of the judiciary is that removing, and the most common argument I hear, is that removing the Constitutional Court would fracture separation of powers between the branches and lead to domination of the court by the legislature. The reality is that the creation of 72A Court is what fractured the balance of power to begin with. It has led to an alliance that has pulled power from the people and their representatives into the executive and judicial branches. The reason has to do with the role of the judiciary and how it is formed. Unlike the legislative branch, which passes positive law, and the executive branch, which enforces positive law, the role of the judiciary is to be neutral. That is, the executive branch prosecutes you, one of us, for breaking a law passed by one of us, and the court is what ensures you receive a free trial. For that role, it needs to be neutral. There are two types of neutrality that are required for this role. The first is partisan neutrality. The second is branch neutrality. Partisan neutrality is achieved by granting a long term of office, primarily, so that if you have an executive, and your executive is swinging to the right and swinging to the left, your court, which retires and is appointed more slowly, oscillates in a smaller window like this, so it buffers the partisan nature of the court. Branch neutrality is commonly achieved by having the executive appoint and the Senate, the executive appoints and the Senate, a branch of the legislature, confirms the appointment. This has the effect of pulling the court in between your legislative and executive branches. In New Hampshire, the partisan neutrality works. This part works. The part where the court becomes neutral between the executive and the legislative branches does not work, because in New Hampshire, the court is entirely appointed by the executive. In New Hampshire, we have the governor appoint and the executive council confirm. The Senate does not do this role in New Hampshire because New Hampshire has a very pointy or small Senate. And there was concern in the design. The pointy Senate and the White House are, I think, wonderful design factors. But the pointy Senate was not going to be appropriate for the appointment of, or for the confirmation of the justice. Instead, they used an alternative mechanism. This alternative mechanism was a dissolution. It's like a parliamentary vote of no confidence. Essentially, your executive appoints your court members, They sit up here, they kind of crank up towards the executive or towards the executive and away from your legislative branch. Eventually your legislative branch notices, gee, this court and this executive are kind of ganging up to take the power away from the judiciary. At that point, they vote to have a dissolution. They go in, they pick out the judges that have proven themselves over a period of time to be bad actors or not neutral, and then the executive does the reappointment. So that over time, what you would have is a drift of your court towards your executive, a reset. A drift of towards the executive, a reset. From 1900 to 1966, this dissolution process was not even used. For 60 years before we did the Constitutional Court, the dissolution was not used. That means that we had an independent judiciary. We didn't even use the mechanism because we didn't feel it was necessary. 1800 to 1900, during the Industrial Revolution, it was only used 5 times. Today, without that power, we do not have branch neutrality, and the court and the executive are now the executive is now asking the court to help it gang up on us. Yanking power away. So, this court is out of control. We have a desperate need to restore a balance, and this is a proven method that was neutral. It achieved preventing the court and the executive from ganging up on us, and also achieved an independent judiciary in the state of New Hampshire in actual practice for 60 years. We removed it. We no longer have it. Please press red to overturn ITL. Thank you. I appreciate your time.
Does the member yield for a question? The member does yield. The member has waived his question. Thank you, Representative Davenport.
Thank you.
The chair recognizes Representative Hagan to speak to the question.
Thank you, Mr. Speaker. I rise to support the ITL recommendation of the Judiciary Committee on CACR 25. This bill would repeal Article 72A, Part 2 of the New Hampshire Constitution, which mandated that the Supreme and Superior Courts are constitutionally established and therefore an independent judiciary. CACR 25 would forever subordinate the aforementioned courts to the General Court. Now, despite legitimate concerns of my side of the aisle about excesses of the judiciary, which has occurred since 1966, the all but unanimous and bipartisan committee opposes the amendment, as it would inexorably fracture the separation of the branches and unnecessarily alter the appropriate balance of power between the judiciary and the legislature. There may be other solutions to the issue of judicial excesses, but this is not the answer. Thank you, Mr. Speaker.
Does the member yield for a question?
No.
The member does not yield for a question. House to come to order. The question before the House is the committee recommendation and report of inexpedient to legislate on CACR 25. The chair recognizes the honorable member from Newmarket, Representative Davenport, for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if you know, as I know, that the court in the state of New Hampshire is no longer a tripartite equal branch, but has become a superpower that can dominate and has dominated and has enjoined with the executive to boss us around in an unconstitutional manner. And Mr. Speaker, if you know, as I know, that this is a proven method that is not radical, was used for 200 years in the state of New Hampshire, where we had no problems of this sort, and then was removed in 1966, and all this I'm doing is, or we are going to do, is restore it to a functional system. Would you please vote red to ITL, and I will then motion probably to table. Thank you.
Question before the House is a majority committee recommendation and report of an expedient to legislate on CACR 25. The chair recognizes the member from Amherst, Representative Rowe, to speak for parliamentary inquiry.
Thank you, Mr. Speaker. As you know, as I know, we have 3 courts in New Hampshire. One is a legislative court, that's the Circuit Court. 2 are constitutional courts under 72A. That's the Superior Court and the Supreme Court. This bill would eliminate the constitutionality of the Supreme and Superior Court. That would mean that the Supreme, the Superior, and the Circuit Court would be under the control of the legislature. The end result of that is we would only have 2 branches. Independence of the judicial branch is important in our form of government. I urge you to press the green button.